Hello students, I am in module 3, second lecture. In this lecture, I'll talk about membership of a company. Okay, who can become a member of a company? We are talking about a private limited or a public limited company. The first thing you have seen here, minor is written. Yes, definitely minor can become a member, but not up till he is 18 years of old. But his name will be written in the register of the membership of the company. As he can hold the shares of the company on behalf of guardian. So guardian will sign on behalf of minor, and once he attains 18 years of age, he can be a shareholder of the company. But as of now, he can become a member of the company. Okay. Second is company. One company can become member of another company simply by buying shares or by becoming a member during subscription. Third is, similarly as company is becoming a member of another company, a partnership firm can also become a member of another company. So all the partners in a partnership firm will become the member of that company. Fourth is insolvent. Any member of the company is declared insolvent, he remains to be a member. That means if he is declared bankrupt or insolvent, his name will not be removed from the register of members. He will be a member of that company. Okay, then fifth one, the last one, any foreigner can also become a member of a company which is registered in India. Now you might be getting confused between what is a member, who is a member, and who is a shareholder. So to explain this, there is a small distinction I have made here. So a shareholder is naturally a member of a company. As he is holding the shares, his name is there in the members list also. But a member may or may not be a shareholder. Okay. Why? Because a company may not have a share capital. It must be a private company or a one-man company. So there are members in those companies, but there is no share capital in those companies. So a member cannot be called as a shareholder, but a shareholder can definitely be called as a member if he is a registered shareholder. Second point here is a person who owns a bearer share warrant is a shareholder. Okay, but that same person who is bearing a share warrant need not be a member. Now, what is a share warrant? To understand this, you need to understand what is a share warrant. A share warrant is a warrant or a kind of a certificate which is given to a person who wants to buy a share. He has not yet become the shareholder, but he wants to buy the share in future. There is some time limit given to those people. If they want to buy the share, they can produce the warrant and they can become the shareholder. So, kind of they are called as a shareholder of a company because they can exercise their warrant anytime, but they are definitely not called as a member because their name is not written anywhere in the register of members. So a person who is holding a share warrant can be called as a shareholder but not as a member. Then finally, third one, a legal representative of a deceased member is a shareholder, but he will not be called as a member. A legal representative means there was some person who was having some share capital, who was a shareholder of a company. Okay, that person died and his legal representative, his legal heir, okay, will be taking that shares, as the shares will be transmitted from the deceased person to the legal representative. So he will be the shareholder of the company, but his name is not written in the register of members. So he cannot be called as a member of the company. Okay, students, we come to an interesting part here, which is prevention of oppression and mismanagement. If you remember, we have discussed in the class about FOSS versus HARBOTTLE case. In this case, there's a company and there are few directors of this company. This company is planning to buy a land which belongs to one of its directors. So these directors were planning to buy this land and for the growth of the company wanted to do some business on this land. So one of the directors who owned this land gave the proposal to the company so that he'll sell this land to the company and he'll get some money from the company, as the company is different from the directors, or the company is different from the members of the company. So there was a meeting conducted regarding this, and in this meeting it was decided that company will buy this land and will do some business on this land. So this land was sold by the director, one of the director of that company, to the company, and company started the operation on this land. After few days or few months, it was found that company went into losses, and directors were very worried about this loss. So in an annual general meeting which is conducted every year by the company, all the shareholders were present. Majority of those shareholders decided that the directors who took these decisions are not guilty of this, and they should not be punished, as it was a business decision and the business decision went wrong. But there were two minority shareholders who were opposed to these directors. So as the majority of the shareholders voted in favor of the directors, this minority shareholders went to court against this direction. There was proceedings in the court. On the one side there were minority shareholders, on the other side there were company along with the directors and along with the majority shareholders. In the court it was decided that court cannot intervene into the internal management of the company based on few principles. These were: first, a company is a separate legal entity from the members who compose it. As such, if any wrong is done to the company, it is the company which can bring an action. That means it is the shareholders of the company who will bring an action. Second, the will of the majority shareholders is supreme and should prevail over the minority. Third, the court will not interfere with the internal management of the company, which is within the scope of their powers. So by these three principles, the shareholders, majority shareholders, the directors and the company won the case, and the minority shareholders lost the case on the basis of that company's internal decision fully rests on the shareholder power. But there are few exceptions to this case. These exceptions are like, if company does something ultra vires act. Ultra vires act, a kind of act which, if a company does anything which is not in the company's control, the company cannot do that. If company has done something, later the company cannot ratify that we have done it, now we cannot proceed further. So if that kind of act is being done by the company, then the minority shareholders can go to the court. Then during this time, court can intervene into the matter. Or second is, any specific fraud is done especially on the minority shareholders. If specific fraud has been done on minority shareholders, only then court can intervene. Third is act which is inconsistent with the articles. If certain things are written in the articles of association, if companies going against those things, against the articles, then court can intervene into the matter. Or a certain resolution which require a special majority, not a normal majority of more than 50%, a special majority of more than 75%. If that is required and the company did not consider that special majority, then again the court can intervene into the matter. And if suppose individual membership right is being revoked by the company unreasonably, that means a person who is a member of the company, he has some rights. For example, right to vote or right to attend the meetings. If that right has been revoked by the member without any specific reason, then he can definitely go to the court and court can intervene into this matter. And finally, if company has breached some duty, If company was supposed to do some duty and they have not done it, they have breached the duty, then again court can intervene into this matter. There are few instances of oppression which I have listed down here. First is depriving certain members to a right of vote or right to elect directors or right to attend general meeting, etc. A member is removed from auditorship of the company without any justification. This is a kind of an oppression done on the member. Third is if company refuses to register the transfer or transmission of shares in favor of transferee in an unreasonable manner, then that person who has the right to get those shares by transfer or by transmission, he can go to the court and court can intervene into this matter. Finally, if there is a creation of a new majority without allowing a certain group of shareholders to participate in the further issue of capital, in these instances court can definitely intervene. These are some of the instances generally takes place and court intervenes into the matters of the company. Now this was about the oppression. Now there is one more term I have mentioned in the beginning is mismanagement. Mismanagement is any improper management of the affairs of the company, and because of this improper management there is a harm to the interest of the company or public interest as a whole or economy or country as a whole. Because of this mismanagement, the people who are connected, the stakeholders of the company, are getting affected. Then this management should also be prevented. When the prevention of this mismanagement happens is by two ways. If the affairs of the company are being conducted in a manner which is prejudicial or harmful to the public interest or to the company's interest, or second, by any material change is being done in the management or the control of the company. That means any top management is being changed or some people are added or subtracted. Because of those people, the affairs of the company may be harmful or may be conducted in a matter prejudicial to the public interest or to the interest of the company. If that's the case, then this mismanagement should be prevented.